Good evening, everyone. It's a great honor to welcome you all to our National Entrepreneurs Day celebration on behalf of Women Entrepreneurs India. Entrepreneurs are the driving force behind innovation and growth. And today we are privileged to have Prateek Shrivastava sir with us, a practicing patent attorney. I would like to invite Nivedita to share a guest profile about you, sir.
Good evening, sir.
Evening, ma'am.
Pratik sir is a practicing patent attorney in India. He is a qualified electronics and communications engineer and an advocate registered with the Bar Council of India. He is he is an empaneled patent startup facilitator under the Government of India. Startup India intellectual property scheme and has an extensive intellectual property. One second, sir. Extensive intellectual property experience. He specializes in counseling on protection and management of intellectual property assets. Sir has represented clients from sectors like information and technology, electronics, fast moving consumer goods, and recognized universities and professors and scholars from universities such as IIT Bombay, NITs, BMJ, Mujpal University, and etc. Sir has also signed MOUs to foster innovation and create an IP ecosystem in India with institutes and incubation centers such as Nehru Group of Institutions, Chennai, and Center for Entrepreneurship and Innovation, Pune. Gwalior Smart City Projects, IIT Engineering College, Great Noida, AIC, Birla Institute of Management and Technology, MITS Gwalior College. Pratik sir has a regular speaker at various IP forums, which are including but not limited to Self for IPR promotion and management, Government of India, Madhya Pradesh Council of Science and Technology, various incubation centers and technical universities in India. He is also an IP mentor to various incubation centers and technical universities in India. Pratik sir is also a member of esteemed international and national organizations such as International Association for Protection of Intellectual Property, Society of Automotive Engineers India, and MSME Startup Forum. He is also an empaneled legal expert. Is a committee formed under Government of India, Kapila scheme by MITS Gwalior and IIM Gwalior and Ramrao Adik Institute of Technology, Mumbai. At PNE Intellectual Property and Technology Attorney, Pratik Sir is in charge of overall end-to-end operations and focuses to technical and legal aspects of intellectual property and business intelligence. We welcome you, sir.
Thank you for your kind words.
We would like to hear a few words from you, sir.
Yes, first of all, thank you everyone for giving me this kind opportunity. I am indeed honored to be a part of this wonderful gathering. My name is Prateek Shrivastava, and I am a practicing patent attorney in India. And I so we also help startups as well as we also help women startups in protecting their IPs, particularly patents and trademark. So as today is the World Entrepreneurship Day, so the word entrepreneurship means to create something. So when you create something, that means that creation should be protected. The creation of mind, that could be anything, your innovations, your artistic creations, your brands, everything needs to be created. So the concept of IP, the concept of intellectual property, comes from the creation of mind that has been created intellectually. So in India we have a dedicated mechanism to protect all these IPs. For innovations we have patents. For trademark, for your brands we have trademarks. For your artistic and literary creations we have copyrights. And for processes relating to agriculture we have protection of plant varieties. For your semiconductor related things we have this protection of Semiconductors Act, and so on and so forth. So, coming to the question of entrepreneurship, we normally see in India that people are normally tending towards working for any company. They are not actually keen towards creating something new. But now things are changing, and people from past 5 6 years have started doing startups, and they have started filing patents. They have started created creating something unique which is actually useful for India and worldwide. So the mechanism of IP is such that if you have created something, that needs to be created. So patents is for innovation, as I say. So if you have created something which you think is innovative, and that needs to be protected, so you must file a patent application first. And by filing a patent application, you can create a market monopoly in India and worldwide. So creating a monopoly means you exclude others from using that patented product or a process. Now in India, if we look at the patenting process, not all inventions which you create, I mean not innovative products which you create, are patentable. So to qualify as a patentable product or a process, you need that invention needs to be unique, that invention needs to be inventive, and that needs to be industrially applicable. If it is not unique, that so patenting is not possible for that. So if that innovation or that invention is not inventive, that is, if it is obvious for a common man, that means it is not inventive. So in that case, patenting is not possible. If it is not industrially applicable, then also it is not patentable. So if you qualify all these three criterias, then also it's not like that all sort of inventions could be patented in India. So for example, if you have created something which is against the public order or morality, so that is not patentable in India. For example, you have created a method to counterfeit currency, so that process and the product of counterfeiting currency is not patentable in India. At the same time, you have created a mechanism to uh, g- gamble, then also that process is not patentable. So there are few non patentability criteria which you need to qualify for filing a patent. So when you file a patent application, it's a misconception that it is granted on perpetuity. So like if you have a patent, you have filed a patent, and the patent office has granted to you, uh, granted some rights to you, so only for 20 years you can enforce it. Post 20 years, anyone can start using that patented product or a process, and you cannot create a monopoly over that patented product. So the question really is like how to file it and where to file your patent application. So how to file means like you need a techno legal expert to file your patent applications. And where to file it, you need to go that there are a few patent offices in India where you can file your patent applications electronically. You yourself can also file it, and you can also take legal help from attorneys. I mean, from professionals like us. Now, coming to the question of trademarks, uh, trademark is something, the word within itself says that the mark which is represented graphically and is used for any goods and services in India. Now let's say for example, you have started your own startup, and someone else is using that name from past 5 6 years. So you cannot use that name and start your own company with that name. So you need to first check it whether the name which you are using for your brand purposes is unique or not. If it is unique, then it is advisable that you should file a trademark for that. You can do whatever with that with that brand or with that trademark. So, unlike patents, patents are granted for 20 years. But in the case of trademarks, they are initially granted for 10 years. But in perpetuity, you can use it, you can pay renewal fees for that, and in perpetuity, you can use it. You can use that trademark. Similarly, for the case of copyrights, not all sort of creations could be copyrighted. What I mean to say is only the artistic creations, the literary creations, and your cinematographic films and your paintings could be protected under copyright. Now, if you want to protect your facts, your functionality under copyright, then it is not possible. So for that, you need to file a patent application, provided it has to be unique and inventive. But in the case of copyrights, only artistic creations such as your paintings, your songs, your book, your computer programs, all these things could be protected. Unlike patents and trademark, patents are granted for 20 years, trademarks are granted initially for 10 years, and in perpetuity you can pay the renewal fees, and you can use that trademark like forever. But in the case of copyrights, the protection is initially granted for a lifetime of an author plus 60 years. Now, if we see, the average age in India is approximately 60 to 70 years. So if we take 70 years as the lifetime of an author plus 60 years, so overall protection which we get in India is approximately 120 to 130 years from the date of filing that copyright, or from the date of creation of that copyright. So this is the overall mechanism which we protect under copyright. So the opportunities which I see as an entrepreneur, uh, like I would advise each and every startup who is trying to create something or has already created something, to file a patent application for that. Because the moment you file a patent application, your valuation increases, and it also creates a trust among investors that, look, this company has a patent. So each and everyone who is doing some sort of innovative activities in their company, or has already done innovative activities, you it is advisable to file a patent application. Or on the contrary, if your brand name is unique, and you think that this brand can be created, and this brand can go internationally, so it is advisable to file a trademark in India, and as well as worldwide. Similarly, in the case of copyrights, if you are a startup, and you have created some sort of computer programs, or you have created some sort of literary works which you think can be copyrighted, apply for the copyright. So by protecting your intellectual property, you can have a market monopoly. And market monopoly means you can exclude others from using your IP. If you have innovation or you have invention, then that patented product or a process could create a market monopoly in India. And if you have a brand which is registered as a trademark, no one can use it. And if someone is using, you can take legal action against them. Similarly, for the copyrights, if you have a copyright, so you have a market monopoly for at least 120 to 140 years. So this is about the IP, and I sincerely would like to thank each and everyone to give me this opportunity. And if you have some questions, I'm open to answer.
That's so nice to know more about patents, sir. We have few questions in our mind. Can
Yeah,
we shoot it, sir?
yes, please, please. Yeah.
So first thing is like, what has been the most challenging patent case like you have worked on, and how did you push your boundaries to the expertise in both technology and law, sir?
Vanusha ma'am, the the point is that each and every aspect of IP is a challenging one. It's not like that these cases are a bit complex or that is more simpler in terms of technicalities. But if you look at the patents overall as well as the ip overall, each and every case is complex, and you require both techno-legal expertise to understand the innovation for for that patent application. So I am grateful for the opportunity I got during my career, that I am both techno-legal expert. I hold a BTech in electronics and communication, and I pursued my law, and I am also patent attorney. So I I try to simplify things as much as I can, but each and every case with respect to patents or it is IP, it is a complex one.
Thank you, sir.
Yeah. Any other question?
I have a question, sir.
Yeah, please.
With your experience in sectors like FMCG, IT, and electronics, what unique IP strategies do you recommend to businesses in these rapidly evolving industries, sir?
See, if you belong to FMCG sector, the first thing is to protect your brand. For example, the brand Patanjali is trademark owned by Patanjali company, which has lots of products, right? So these FMCG products are under the umbrella of Patanjali products. So, in my opinion, for FMCG products, it is important to file a trademark first to get the trademark registered. For IT companies, it is advisable to protect their computer programs which they have created. I mean, they have written as a code. So, in my opinion, they must file a copyright for it. And if they believe that their computer program is beyond technical contribution, if they have created something unique and which they believe could change something in the society, they can also consider filing a patent application for that. So for IT companies, it is advisable that they must go for copyrights and filing patents. Now, in the case of electronics, the see the we have lots of electronics related companies in India and worldwide who file patent applications as soon as they create something. So it's like you need to have that understanding as to how patenting mechanism works in India and worldwide. So if you think that you have created something and that could change the society, and you think that this is actually trying to solve some sort of problems in India and worldwide, so filing a patent is a best option to create a market monopoly. So for FMCG products, it is first advisable to protect the brand. For IT companies, it is advisable to protect their computer programs, and they have if they have created something which is beyond the incremental innovation and is beyond the technical contribution, then it is advisable to file patents. And for electronics company, it is highly recommended to file a patent application as soon as they create something.
Thank you, sir. We have a question in the comments. Can I read it for you, sir?
Yeah, please, please.
As a mentor and speaker, how do you simplify complex IP concepts for your audience while maintaining their technical and legal depth?
Ma'am, it comes with experience. It's not like that I'm trying to create something. I'm trying to simplify things. It's not like that. It comes with experience. The more I read, the more simplify. I could simplify the legal complex terms for our students and faculties. So it's not like I'm trying to simplify. It comes with experience.
Yes, sir. I have another question, sir. Like, in your opinion, what is the most underestimated aspect of intellectual property management that startups and universities should pay more attention to?
Yeah, for the universities, I would recommend to focus more on the quality part. So right now, the patents that are being filed in India uh, are not even considered as inventions; they are innovations. That innovation means they are mere incremental innovations. So, in my opinion, as a first step, what universities need to do is to focus on the quality part. What universities are doing right now is they're filing a number of patent applications, they're getting their patent granted in India, but they're not even focusing on the commercialization of that patented product or a process. So 5 years down the line, the boom which we are seeing right now in India will come downwards, and we will see less number of patent filings if you're not trying to commercialize the patented product or a process in India. So what apart from all these things, what universities are doing is they are focusing on the academic credentials. They are filing patents only for the academic purposes right now. So in my opinion, they have to think beyond the academic contribution, and they need to focus more on the quality instead of the quantity purposes. And for the startups, I would recommend to play offensive. So and why so basically, if we really look at the number of patents that are being filed by the startups, is because the investors want them to file a patent application. The investors are recommending them to file a patent application, or if they have created something, they want to protect it so that no one could copy it. Unlike US and Europe, where the contribution of IP is more than 55% in their overall economy. What they're doing is, if they have a patent, they focus on going towards people who are trying to exploit their innovation. So what I'm trying to say is that if you have a patent, or if you have created something and you have filed as a patent application, or you have got a patent, so the first thing is to exclude others from using that innovation. And like China is doing right now, like US is doing right now, if they have a patented product or a process, they exclude others from using that patented product. So in my opinion, in my humble opinion, they should play offensive instead of playing on a safe side.
Thank you, sir.
Yeah.
I have one more question to ask, sir.
Yes, ma'am, please. Yeah.
Uh, as an empanel patent startup facilitator, what are the most common challenges you observe startups facing in protecting their innovation, and how you help them to overcome these, sir?
The first issue which I normally see is with respect to the costing part. Uh, so when so Initially, when we were starting, the cost of filing patent was so high that not anyone or everyone could afford it. So with the schemes such as, there is a scheme called Startup India Intellectual Facilitation Scheme, wherein if the startups wants to file a patent application, I mean, if they have this DPIT recognized startup certificate, they can file a patent application, and they can file it without spending any professional fee for filing a patent. For example, they have created a list of patent facilitators in India. Like, if you are filing patent applications through these facilitators, you can file patent applications without spending the professional cost. Only the government fee, which is the bare minimum cost, is required, and no professional fee is required in that case. Similarly for trademarks, and similarly for any designs. So for trademark as well, if you are filing a trademark through the impaneled facilitators, then only the government fee is required. No professional fee is required in this case. So in my opinion, if you are a startup and you think that you have created something and that needs to be protected, so you can file n number of patent applications without thinking of the professional cost. That's the first thing. So the most challenging part which I see is the costing part. As I say, this is the only thing which I observe while dealing with startups. Secondly, there is one more scheme which I want to talk about, is the MSME scheme, wherein if you have a patent or you have filed a patent application, the government is here to support you. Government is spending 1 lakh rupees for filing a patent application in the case of MSME, and in the case of startups, they are what they're doing is they are not even asking startups to pay the professional fee to professionals. So this is what schemes are going on right now. So the only issue which I see is the costing part, and people are not aware about these schemes. So it's our humble opinion to all startups, or all women enabled startups, to look for patent opinions, file for patents without even thinking of the professional cost.
Thank you, sir. We are very delighted in having you for this event, sir. I hope our
Thank you.
viewers and even myself we got to know more about patents. Thank you, sir.
Thank you, ma'am. Thank you.